Hello, everybody. Sorry about the abrupt end to the first part. I forgot I had shortened it that much. Okay, so we've got then 11 slides counting this one to finish up. So let's get going. We're still in Fourth Amendment. We're still in searches and seizures. So we get to the point where we get this thing called the exclusionary rule. So you have to tie the exclusionary rule to excuse me, the Fourth Amendment searches and seizures, and then to the case that will follow, which is not one of our big ones, but you have to know it. So the idea here is that the exclusionary rule is the evidence, no matter how incriminating, cannot be introduced and used at trial if it was not obtained properly or constitutionally. Sorry. The rule prohibits the use of evidence obtained through unreasonable searches and seizures. And until 1961, it applied, as a lot of the Bill of Rights did, right? To federal jurisdiction only, until it was incorporated in 1961. I'm going to pause this for a second to cough. Okay, so the exclusionary rule idea was then incorporated to the states in 1961, right, through 14th Amendment Due Process Clause. And the case that did it was a case called Mapp versus Ohio in 1961. So you have to know Mapp versus Ohio incorporated the exclusionary rule, Fourth Amendment. So the idea is that police broke into her home looking for a fugitive. They had a warrant. She ran a boarding house, basically, and they had a proper warrant to enter the home and search for this fugitive they were looking for, who lived there, but he was gone. But as they were searching through the house for this guy, they came across illegal. And so this case took place in like 1958, something like that. The actual thing that happened. So they found what were called in Ohio at the time illegal obscene materials. Probably, since 1958, obscenity has changed so much. It was probably something you'd see on PG TV now. Who knows? But they found illegal obscene material, at least illegal for Ohio at the time. But they were hers, so they had no probable cause to search for those things. Okay, they had probable cause to search for this dude, but not for this. So she was convicted at trial. Her name is Doralee Mapp. And she was convicted at trial. That conviction was upheld at the appeals court, circuit court. And then the Supreme Court overturned or reversed that conviction. And by that, saying that the search warrant did not allow them to seize that particular material because it had nothing to do with what they were searching for. So it was illegally obtained evidence, so they had to throw it out. So her conviction was reversed. And it incorporated, at the same time, the Fourth Amendment. Now, there's always an argument, there always is still today. The critics of this say it's too strict, and they use this word technicality. People shouldn't go free based on a technicality, and you'll see that a lot. But the supporters of the idea say that the idea is innocent until proven guilty, so it protects the accused. It doesn't protect the guilty, but it protects the accused. And either way you look at it, those things have a valid point either way. So it just depends on where you fall on the scale. So a little bit more on it. There are, of course, exceptions, lots of exceptions. Sometimes the evidence can be allowed if it was illegally obtained, but the judge and the court rules that eventually they would have found it anyway. Okay, all of this is really technical lawyer stuff. So I'll just give you an idea that there are exceptions. There's what's called a good faith exception. Evidence might be allowed if the police seized it illegally, but they thought they were acting legally. Okay? So you never know where that falls. Like, they thought they had a valid search warrant, but it turns out maybe the search warrant wasn't valid. The judge signed a crap search warrant or something. But they thought it was valid, so it still might be allowed. And clerical errors are allowed as well. Wait a minute, you misspelled my name, so that search warrant can't be allowed because you misspelled my name. That's not me. So that's sort of the idea there. Those are allowed. Okay. A little bit more. So what's not allowed? We talked about what was allowed. Some things that aren't allowed. A car search. Remember, I'm not a lawyer. Don't forget that. A car search is generally not allowed when stopped for only speeding. You don't tell the cop that. Don't tell him, my AP government teacher told me you can't search my car. Okay. If they search your car and it turns out to be an illegal search, you're going to have to deal with that in court. Don't resist. Guys, don't resist, because then you will get in trouble and you will be convicted of a crime of resisting. So don't. However, even with that, passengers and drivers can be told to get out of the car, and they can be searched for weapons. That's for officer safety. If nothing else, supposedly there's no justification for a search of the car. I'm not a lawyer. Remember, we said there could be highway checkpoints for DUI, but there can't be highway checkpoints just to catch ordinary criminals doing ordinary stuff. And lastly, no thermal imaging. Remember, they can fly over your property and see your marijuana plants, and then they can get a search warrant, and that's all legal. But they can't sit in the street, public property, and use a thermal imaging device to image your house, see hot spots where you might be growing marijuana indoors with thermal lights and all that. They can't do that. Technology is catching up. The law is catching up to technology. Technology is always ahead of the law. So there'll be more things like this, cell phones and this kind of stuff. All right, let's move along. Fifth Amendment, self-incrimination. This one's really quick. Remember, the burden of proof in our system rests on the prosecutors, which means a suspect cannot be forced to help with their own conviction. This is the idea of self-incrimination. This is the relevant portion of the Fifth Amendment here. And the case that goes with that, so you have to know this case. Again, it's not one of our 15, but you got to know this case because it's about self-incrimination. And it's a case, if you've heard of any of these, you've heard of this one. Miranda versus Arizona, the Miranda case. There he is, Mr. Miranda. What the Miranda case does was it established guidelines for police questioning, national guidelines. So suspects must be informed of their constitutional rights. This is where you might have heard it, right? You have the right to remain silent. You have the right to stop answering questions. You have to be told that what you say can be used against you. You have a right to have a lawyer during questioning if you want, and the court will provide an attorney if you cannot afford one. That one we will deal with in the Sixth Amendment as well as the Fifth, which is our major case for today and the assignment. So again, exceptions have been made over time. There are exceptions. Coerced confession does not necessarily taint a conviction. This is all real legalese stuff, because the lawyer might say, and they might argue, and the judge might agree, and the court might agree. If other evidence is enough, the confession might be called a harmless error. Okay. Bottom line, just like Amendment 1, there's nothing absolutely clear cut here. Okay, so the Fifth Amendment also forbids coerced crime, like entrapment. We call that entrapment, which means law enforcement officials, you cannot, as a law enforcement official, entice a person to commit a crime they wouldn't have already committed, or they wouldn't have committed otherwise. Okay, a lot of this you'll hear if you think about prostitution cases. Wait, she entrapped me. The police officer was posing as a prostitute and they entrapped me. It's not really going to work, but that's sort of the idea. But they can't force you to commit a crime. Well, not force you, entice you, as it says there, to commit a crime you wouldn't have committed otherwise. And it's obviously ultra fine line here. Okay, let's get to our case. Then Sixth Amendment. Sixth Amendment has a lot of stuff in it. You can see there. We're concerned with the last two sentences. The right to counsel. That's what our case is about. Gideon versus Wainwright, our case today, and it's one of our 15. So it incorporated the right to counsel for more than just capital crimes. What is a capital crime? A capital crime is a crime where one of the possible punishments is the death penalty. Okay, that's what is a capital crime. The Supreme Court, in a prior case called Betts versus Brady, had ruled that that states had to provide lawyers if the case was a capital case, but in other cases they didn't have to. In this case, Florida did not, and you'll read that in the assignment today, so you'll get the particulars there. But the Gideon case extended the right of poor or indigent people to counsel provided by the government in all felonies. Okay, so it changed it from capital crimes to all felonies. And you'll see that in the assignment later on. Next week, you'll actually your assignment will only be to watch it's actually a movie about this case. It's called Gideon's Trumpet. and that movie takes about just a little under an hour and a half to watch it. But it'll be just there. I'll put a YouTube link will be on there, and you can watch the movie so you can get an idea of this case. Since this case, though, the court has extended it to a crime whenever prison can be a sentence. So it also applies now this Gideon ruling where if you can't afford a lawyer, the state has to provide you one on some misdemeanors as well. If jail is a possible sentence, then a misdemeanor, they also have to do that. Okay, last slide today. So we got some ideas. Remember, there's other things in there, trial by jury. And there's a jury there for you. 90% of cases never see the courtroom because they're plea bargained down, all that kind of stuff. So we actually get to the courtroom with cases. Remember that funnel I was talking about at the very beginning. So just one quick thing, last thing about juries. So we have the trial by jury. How many? Most of you, hopefully, if it came to your mind, would say 12, and that's true. Federal is 12. For most cases, states are also 12. But states, it has been ruled that states can, in very minor cases, some states do, and Georgia is one of these cases, for really, really minor things, six people can comprise a jury. All right, so this is it for today. Welcome back. Glad you are back with us. Remember, there's an assignment. The Gideon versus Wainwright is the case, and then we will get back to it on Friday with another one. And so we'll finish up 4 through 10. There'll be a few less slides, and then the case for that day will be Roe versus Wade. So with that in mind, we'll see you then.